Hello, I'm Baijal. I lead the Insolvency team here at BBM. In this short video, I want to give some guidance, particularly to directors but also to their advisors and their accountants, about the different restructuring methods for companies in financial distress. These are the most common methods that are available here in Scotland. They will be familiar to many people, but if you pick up a newspaper, some of the terms I'm going to use, such as administration, liquidation, CVAs, they're used interchangeably, where in reality they are different procedures which are suitable for different type of cases. The procedure that is most appropriate will really depend on what state the company is in. In some cases, where a company has financial distress, it may be caused, for example, simply by one creditor on a one-off basis, where negotiation with that creditor and some debt forgiveness by that creditor can cure the issue and the company continues to trade profitably thereafter if the core business is strong. In a case like that, debt forgiveness is the appropriate route to go down. And in fact, a formal insolvency or restructuring procedure may actually not be required. At the other extreme, if you have a company that, for example, has stopped trading, is hopelessly insolvent, has no assets, no income to come in, and really all that is left to do is adjudicate on the claims of the creditors and split up what little there is, the most appropriate procedure will be liquidation. We often refer in the profession to liquidation simply being about giving a company a decent funeral, and that's a good description of what a liquidator does. He or she will go in, they will take the assets of the company that are left, they will sell them, they will effectively pool them for the benefit of the general body of creditors after any secured or preferred creditors have been paid, and then they will distribute what is there between the creditors by what is known as a dividend. Sadly, in Scotland today, in some liquidations, there is very little in the way of dividend actually to go out to the general body of unsecured creditors. It's also important to note that one of the liquidator's main duties is actually to investigate the cause of the liquidation and to investigate the conduct of the directors. He or she has to complete what is known as a D1 report on the director's conduct. That is submitted then to the Insolvency Service, who make a decision about whether to pursue directors' disqualification proceedings against any of the directors, for example, because it's felt that their conduct has fallen below what would be expected from a reasonable director fulfilling their duties toward the company and its creditors. Administration is a relatively new procedure that arrived in the early 2000s in Scotland. Administration allows a company in distress to apply for a moratorium, where for a period of time the creditors of the company cannot take action while administrators to the company are appointed. Administration is a formal insolvency procedure. Originally it was intended that administration would be a rescue procedure, and in fact the first and primary aim of administration is to save companies. In fact, in very, very few cases is the company actually saved. However, administration is often successful in saving the business of the company. Now that is an important difference to make, the business and the company. The company is the legal entity. The business is the trade of the company. And very often, for historic or legacy reasons, a company will have problems that it cannot recover from. Some kind of debt that is weighing around its neck like a noose, perhaps a big claim of some kind. But actually the business is sound. Administration allows administrators to take the business of the company and to sell the business even though the actual legal entity, the company, is finished. And from that point of view, administration has been successful in preserving enterprise value and saving probably millions of jobs over the last decade and a half. You might have heard people speak about receivership. Receiverships are on the wane in Scotland. That is because receivers can only be appointed by lenders who have a floating charge in their favour that was granted before 2003. If you don't have bank lending, or your bank lending does not originate from before 2003, you probably need to be less worried about that, but you should take advice. Nowadays, bankers will usually have the option of appointing an administrator. However, what a receiver did was a receiver went in on behalf of the floating charge holder and liquidated whatever assets it could to get the floating charge holder out. Very often on the back of a receivership, the company would then go into liquidation. Just to complete a quick commentary on the different options available, we should also remember that creditors' voluntary arrangements exist, whereby a company can propose a CVA where, under the guidance of an insolvency practitioner and the supervision of an insolvency practitioner, it can be proposed that creditors will be paid so much in the pound, or certain types of creditors can be paid so much in the pound. Now, a CVA can be useful where there is a strong core business, but there is a particular problem with one type of creditor or a legacy of creditors. So, for example, they've been used successfully in the retail industry, where perhaps some rents have been too high for retail units so far as the tenants are concerned, and a CVA is proposed whereby they offer to pay historic rent arrears simply at so many pence in the pound. It's important to note, though, for SMEs, for smaller companies, the HMRC in general terms remain completely opposed to CVAs. It's perhaps for that reason that we have not seen their wide use in Scotland. It's impossible for you to take from this video what the correct option is for you. In order to decide the best and the most appropriate insolvency and restructuring option for your company, it is incredibly important that you take independent, expert legal advice, and probably also that your lawyers have input from a strong insolvency practitioner too, to decide what the best option is for the company and the best option is for the creditors.